Washington Journal continues.
Joe DeGeneva, who is Brian Pagliano?
Brian Pagliano was a former State Department employee, former contractor, who was and former Clinton campaign worker, who was hired by Hillary Clinton to install a private server to do all of her government and personal email correspondence at her home in Chappaqua, New York. He was also simultaneously employed by her as a computer advisor at the State Department.
He's been granted immunity, correct?
The federal prosecutors at the Department of Justice have granted him immunity according to published reports.
And first of all, what is immunity and what does that mean?
If it is statutory immunity, which is the immunity where you go before a judge and the prosecutors say, we want to be able to ask this person questions in front of the grand jury, if it is statutory immunity, it means that anything that he says in the grand jury or in the interviews with the FBI and the prosecutors can never be used against him. But more importantly, anything that he says can never be used to develop a lead against him, which means that invariably, when you're granted immunity, you can never be prosecuted for the crimes for which you have been granted immunity.
The fact that and you talked about statutory immunity, is there another type of immunity?
Yes, there's something called letter immunity, where a prosecutor hands your attorney a letter that says, we won't prosecute you for anything that you tell us in an interview, but we can use it for leads in the investigation. Sometimes people will have their attorneys deal with the prosecutors because they want to get out of a case and they want to talk, but they want some limitation on it. And what the lawyers go in and they make what's called a proffer. They tell the prosecutors ahead of time what the witness is going to say. And if the prosecutors like it, they hand them what's called a letter of immunity saying whatever you tell us can't be used against you directly, but we can use it to develop leads.
So, do we know for a fact that Mr. Pagliano has been granted immunity?
We do know for a fact he has been granted immunity because his lawyers told the House committee that he has been, and they also told the press that he has been granted immunity. What we don't know is what kind it is. In all likelihood, given his centrality to the entire story of the private server in New York for Mrs. Clinton, it is statutory immunity, which would mean that there is a grand jury sitting which has at least issued subpoenas.
So, what's the significance of all of that?
The significance is that it means that notwithstanding what Mrs. Clinton and her supporters have been saying, which is, quote, it's only a security review of her computer, it is not. It means that we now know formally it is a federal criminal investigation being conducted by the FBI with the assistance of lawyers from the Criminal Division and the National Security Division of the Department of Justice.
Does there have to be intent in a criminal case?
In most criminal cases, intent is required. Sometimes it's just the intent to do the acts. Sometimes it's the specific intent that you want to murder someone. In these cases, there are two types of intent. In the criminal investigation of whether or not classified information has been compromised, there is something called gross negligence under the espionage statutes. If you mishandle classified information, don't store it properly, send it to people who aren't entitled to have it, put it on a private server in a home, send it to somebody who doesn't have a security clearance, that is called gross negligence. That does not require any intent other than the intent to do the act of actually compromising. You don't have to have any evil intent or anything. In some of the espionage statutes, you have to knowingly, what they say, knowingly compromise information, knowing that you're doing something that's bad. So both of those are at play in the Hillary Clinton email server investigation.
Do you think that there was criminal intent or gross negligence?
Well,
in this case?
Here's how I've analyzed it. I asked myself at the beginning of this, what would I do if I were the U.S. attorney investigating this case? And here's what you do. The first thing you do is you look at what General Hayden, the former director of NSA and the CIA, has called the original sin. What was the original sin? It was setting up a private server in a private residence in New York upon which all of the secretary's government business would be conducted. She would have no .gov account. She would only have the account in the private server in Chappaqua. When you look at that and you see why would someone do that, the question I ask myself as an investigator, the answer I get is to avoid disclosure, to evade, to prevent people from finding out what's there. Because if it's in a government server, there will be thousands of people that theoretically could know what is on the server. If it's a private server and only you and a few people have access, that is the intent to evade and hide. For example, if it's on a private server and the State Department receives a subpoena from a federal court in a Freedom of Information Act case, the State Department searches, they say, we have no records for Mrs. Clinton, because they don't. Because the records exist on Mrs. Clinton's private server. That is exactly what has happened in these Freedom of Information cases right down the street here at the federal courthouse. Judge Emmett Sullivan has discovered, well, nobody told me there was no government account. Now that we know there's a private server, I want to take testimony from everybody involved in that process.
Joe DeGenova is our guest. He has been a U.S. attorney for the District of Columbia during the Reagan administration. He prosecuted John Hinckley. He's been a staff director at the Senate Rules Committee. He's investigated Governor Spitzer up in New York. He's named special counsel by the House of Representatives to look into the Teamsters in the 90s, several different positions. And he and his wife, Victoria Tunsing, have their own law firm here in Washington, D.C., focusing on criminal issues?
Criminal, legislative, regulatory. And let me say, one of my proudest things is that I was present at the creation of C-SPAN with the vote in the Senate by Howard Baker to televise Senate proceedings, along with my boss, Senator Charles Mathias, the senator from Maryland at the time. We helped launch C-SPAN, one of my proudest moments.
Did Mac Mathias vote in favor of it?
Oh, absolutely.
Okay,
he favored cameras everywhere, including federal courts.
Too bad he's not around today.
Yeah, God bless him.
Well, Joe DeGenova is our guest, and we're talking about the Hillary Clinton email investigation. We want to get your points of view as well. Numbers are on the screen: 202-748-8000 for Democrats, 202-748-8001 for Republicans, and 202-748-8002 for independents. I want to show you a little bit of video and get your response. Sure. This is Hillary Clinton at a recent debate.
It wasn't the best choice. I made a mistake. It was not prohibited. It was not in any way disallowed. And as I've said, and as now has come out, my predecessors did the same thing, and many other people in the government. But here's the cut to the chase facts. I did not send or receive any emails marked classified at the time. What you're talking about is retroactive classification. And the reason that happens is when somebody asks, or when you are asked to make information public. I asked all my emails to be made public. Then all the rest of the government gets to weigh in. And some other parts of the government, we're not exactly sure who, has concluded that some of the emails should be now retroactively classified. They've just said the same thing to former Secretary Colin Powell. They have said, we're going to retroactively classify emails you sent personally. Now, I think he was right when he said this is an absurdity. And I think that what we've got here is a case of overclassification. I am not concerned about it. I am not worried about it. And no Democrat or American should be either.
The questions were, Secretary Clinton, the questions were, who gave you permission to operate? Was it President Obama?
There was no permission to be asked. It had been done by my predecessors. It was permitted. I didn't have to ask anyone.
If you get indicted, would you drop out?
Oh, for goodness, that is not going to happen. I'm not even answering that question.
Joe DeGenova.
Well, what's interesting about that, and I think really the most important point from the entire comment, is that when Mrs. Clinton refers to others having done it, like Powell, Condoleezza Rice, and Madeleine Albright, that is actually not true. While they may have from time to time used their private email account to send an email to the State Department, not one of those former secretaries of state had a private email server in the basement of their home from which they conducted all of their government business. That is what this case is about. This case is not about emails. It is about the server. The server is the essence of the case. That's why Brian Pagliano was so important. That's why the FBI has subpoenaed documents along with the federal grand jury from third-party servers, people who provide service for that computer. The issue is not the emails but on a private thing. It clearly, however, does relate to the use of, let's say, When you have that private server in your home in Chappaqua, and it's off the grid, it's not government, it's not encrypted, it's not secure, and you know that everything going through that, no matter what its classification, is going to be theoretically compromisable. And when you and your staff use BlackBerries that are not encrypted, or iPhones, or Droids, and you communicate with iPads through that computer, all of that information is compromisable. So the bottom line is, and by the way, classification, when the secretary, when she says, she may be right. She may have never sent or received anything marked classified. However, that's not the standard under the statute. The espionage statutes and the gross negligence statutes say nothing about the labels on a piece of paper or an email. What matters is the substance of the information in the communication, and it is the duty of everyone who has signed a so-called non-disclosure agreement when they are given their top secret security clearance. They sign a piece of paper that says, I know it's my duty to know what's classified, whether it's marked or not. The classification markings mean nothing when it comes to whether or not something is classified.
If you were defending Hillary Clinton, or if you were hired
Yes.
to be on the other side of this issue, and you're not on either side,
No,
this is just,
no.
What would you tell her?
I would tell her, number one, don't be interviewed by the FBI, because if you lie, you're going to be in the same boat that General Petraeus was, which is going to make the FBI want to go after you even more, because understandably, when you lie to a federal investigator, that creates an incentive to work harder on the case, especially when they know you're lying. Maybe they find out later, but right now, given what the FBI knows about this case, they know who's lying and not lying right now. This is an easy one for them. They've got this case locked in. We know from published reports and from conversations with former FBI agents that they believe that they have a locked case. They believe that the issue of how many people within the Clinton circle at the State Department were involved is now a manageable number, and that there may be more people immunized who are not as high up the totem pole as the Secretary or, say, Cheryl Meals or Uma Abedin. The key may be very much Patrick Kennedy, who is the Undersecretary for Management. If I were representing Mrs. Clinton, and I think this may be part of her defense, she'll say, look, the State Department knew I had this set up all along. They didn't stop me. They didn't tell me not to do it. Nobody came and seized the computer. There's no correspondence saying I shouldn't do this. Unfortunately, that's not a defense, because for her, she is one of the 10 people in the United States government who has the generic statutory authority to classify information. There's only 10 people who can do it. She has the power to assist in the declassification of that. So her duties in terms of knowing things about classified information are much higher. So when Patrick Kennedy doesn't stop her from putting in an email server in her home to conduct all government business, even though after January 2009, people may not have known right away that Mrs. Clinton didn't have a .gov account, but within a couple of months, everybody knew. Isn't it funny there are no .gov emails from the Secretary or her staff? At that point, what the department did or didn't do becomes irrelevant to the criminal investigation, because she's in line as the Secretary of State to be President of the United States. So along with her job, not only to conduct foreign policy, comes the duty to understand and know classified information. That is the envelope from which the FBI is operating. This is not a GS2 who accidentally slips a piece of paper in the wrong file and it stays out all night on somebody's desk. This is a person with the highest classification authority possible who used a private server to conduct all of her government business. And without any, this has nothing to do with politics. That's illegal, per se. And the reason is very simple. The government has a classified email system for a reason. It's to protect the integrity of national security information, national defense information, and to prevent its disclosure to unauthorized persons. The existence of that server violates every known federal law on the protection of classified information.
Let's get to calls. Joe DeGenova is our guest. Rose is in Monroe, Michigan on our Democrats line. Go ahead, Rose. Thanks for holding.
This man's been missing or hiding or whatever, because he should have been the one to go to the White House with him, and he didn't.
Rose, what are you referring to?
Well, I'm referring to that Hillary Clinton has got so much baggage she could fill an airplane hangar. You know, and the problem is that these people are just feeding into these like a fairy. She's telling these people a fairy tale. I mean, that's why the FBI is going after her. They want the truth, and she won't give it to them. So guess what? They're going to go after the people that she hired to be around her, and that's why they're giving them immunity, because they want the truth. And
all right, I think we got the point. Joe DeGenova, when you, as a prosecutor, former prosecutor, would you have gone after Brian Pagliano?
Absolutely. I think what the FBI and the Justice Department prosecutors are doing is precisely the right thing. You always try to work your way up because, for example, people are saying, well, why haven't they interviewed Hillary Clinton? Well, you never interview the ultimate target of an investigation first. You interview that person last after you've talked to everybody else, you've subpoenaed documents, you have a full file of information to ask good questions. The way you build a case is you take the people with perhaps a lot of information but no responsibility, and then you build your way up. Brian Pagliano is the linchpin of this case because he set up the server. He was hired to do so specifically, and interestingly enough, he never told the State Department, by the way, that he was on the Clinton private payroll. He lied on his government disclosure forms, and that's one of the reasons he had to be granted immunity, because that lie, that failure to disclose, was a federal crime.
Sometimes, is it a big deal crime?
It can be a misdemeanor. It can also be a felony, depending upon what it relates to. The point was, when he did not reveal that he had 2 jobs for Mrs. Clinton, one off the payroll, that became a crime, and everything else taken together, he was the perfect person to immunize. I would have immunized him just as they did, and I probably would have waited as long as they did, because what they did was they subpoenaed records from third parties about him, bank records, records of his computer service company, and that's why, of course, there is a grand jury, because they can't issue subpoenas like that without a grand jury authorizing it. So they did exactly the right thing, and I would have done it.
Tweet. At this point, shouldn't the DOJ appoint an independent special prosecutor?
Well, I will say this. Of course, there is no independent counsel statute anymore. That was repealed by Congress quite a while ago, a bipartisan desire not to have it around. However, there is a Justice Department regulation that allows for the appointment of a special counsel when there is a personal, financial, or political conflict of interest between the department, any of its senior officials, and the target. At this point, if I were Loretta Lynch, I would certainly appoint a special counsel. Why would she visit upon herself the responsibility for making this decision in a political year? Loretta Lynch has a very good reputation, having been U.S. Attorney in Brooklyn and New York twice. She's been confirmed.
Do you know her at all?
I've never met her. I know her work. She seems to be a seasoned professional prosecutor. She has studiously avoided answering questions about this investigation. Interestingly enough, she did not deny that there was a grand jury when she was categorically asked that question recently. I certainly would appoint a special counsel under the regulations, because no matter what she does, if she refuses to go forward based on the publicly available evidence, I don't know how she will justify it, because the evidence now requires a grand jury beyond what's already been started. And if she were to go forward, she's going to incur the enmity of people she doesn't have to. I mean, the best thing for her to do is appoint a special counsel. Now, if you do that, it's going to take time, because that person has to have a staff, they have to get up to speed, et cetera, et cetera. Who knows? We shall see. This will be very fascinating to watch.
Jack, Dallas, Republican. You're on with Joe DeGenova.
Hey, Joe, how you doing? I'm Jack Strickland. The question I don't see being addressed is the abundance of references in her emails about AIDS, Skrillex. And what's
Sorry about that. We're going to go ahead and move on to Maria in Deptford, New Jersey. Maria is an independent. Maria, please go ahead with your question or comment.
Yes, hello. I'm so honored to talk to this gentleman. I have 3 questions, and maybe they're far afield. I understand he says this pertains only to the server, but I was just wondering, he mentioned espionage. What about treason? If she used the server to make a deal through the foundation to get most of our uranium shipped to a foreign country in exchange for contributions? And also, in the New York Post, they said that Sid Blumenthal, a personal friend of hers, got contracts that would help him in foreign countries. So I guess what I'm asking is if he could explain high crimes and misdemeanors. It would mean misdemeanors in a person of high rank. So beyond impeachment, is there some other I don't want her let off the hook and just said, oh, you can't run right now. I'd like to see prison time if she's found guilty of this. So I appreciate his answer. Did give compliments to Judicial Watch, who has done a lot about this. Thank you very much.
Well, first of all, treason is out of the question because it doesn't, anything that may have happened in this case does not appear to match the special rules in the Constitution and statute for treason. Second of all, impeachment is out because she's no longer in office, so impeachment is simply political and legal removal from office. However, the issue of the foundation and its relationship to the server and any acts which may have been committed, official acts, in exchange for monies donated to the Clinton Foundation is now part of the FBI investigation. We know from published reports, and I know from conversations with former FBI agents, that the FBI, believe it or not, has a copy of this book, Clinton Cash, and they have delved into it deeply. And what's happening now is that the Russian Boeing deal, where Boeing went after Mrs. Clinton to help them get a multi-billion-dollar contract with the Russians for Boeing aircraft. They were fighting with Airbus, the European giant in airplane production. Shortly after the Russians awarded a contract, the Russian government awarded contract to Boeing, Boeing donated $900,000 to the Clinton Foundation and then another $2 million to the State Department for a special program. We now know that the agents are focusing on that. And they are also focusing on a number of other things involving Russia, including the uranium deals. So actually, that is, while it's part of the server, because the agents, as you know, one of the things the agents have done is they've gotten the server plus another server plus 4 servers from the State Department. They have 6 servers in their possession. They are trying to recover the 30+ thousand emails that Mrs. Clinton has said were personal and were deleted. The agents are operating under the theory that the personal emails, that personal equals Clinton Foundation, and that therefore things were deleted about the foundation which have something to do with cash and official acts. So that is clearly underway at this point. The lady is correct.
Joe DeGenova, you said that we know. Have there been leaks in this case? Have there been press conferences?
What's interesting about this is Washington is a 62 square miles of political space. We have no industry. There's not even a new car dealership in the District of Columbia. There are a few gas stations, and then Washington is all about government. Government is about connections. Government is about knowing people. Government is about passing legislation, holding hearings, issuing rulings, challenging those rulings. Former FBI agents talk to current FBI agents. Former Secret Service agents talk to current Secret Service agents. When all is said and done, there are few secrets in this town. And one thing that we know for certain is that the agents who are assigned to this case, and now it's a 150 according to the latest count, they are doing both an investigation of the server and how it was used and what was compromised. We know that as a result of analyzing the server, we know from intelligence sources that there is now a major damage assessment underway to see what was compromised as a result of the server. And we also know that now that the Boeing deals and other things are being, and the reason is, when the FBI go out and they talk to somebody about something, those people that they talk to, these witnesses, they're not bound to secrecy. They talk to people. And they say, I had the strangest visit today from an FBI agent about something involving Boeing aircraft. So the answer is, Washington's pretty good at keeping some secrets, but not very good at keeping many secrets.
Who makes up a grand jury, and have there been leaks out of the grand jury?
There is no evidence to date that there have been any grand jury leaks whatsoever. Usually, grand juries are about 16 people. They are citizens of the community, usually registered voters or people with driver's licenses. You don't have to be a registered voter to be a member of a grand jury. When you're sitting on a federal grand jury, you sit for usually a year, and you come in maybe once a week or twice a week. Sometimes, if it's a very special case, you'll only sit on that case and nothing else. So it's America's way of having citizens vet the evidence.
But, and once again, do we know for a fact that there is a grand jury?
No one has announced that there is. However, we know that if Brian Pagliano was granted statutory immunity, there would have to be one. And we do know that subpoenas have been issued to third parties, and in order for those to be issued, there would have to be a grand jury.
Phyllis, Arlington, Texas, thanks for holding. You're on with Joe DeGenova.
Hi there, Joe. This is, I am an RN, JD, and a criminal psychologist. I just want to know why all of a sudden we've all known about these emails, and I worked for the government for many, many years before when I was in college, and they came and got me, all the way up from the top to the bottom, to the side, to the west. I know where all of them's got the servers at, especially come on down to Texas, and I could take you all the way through the Capitol line. But let me tell you something. What he is saying about Hillary Clinton, I know Hillary Clinton very well myself, and I'm going to tell you something. If it wasn't Hillary Clinton, this would not even be out. She wasn't running for president. It wouldn't, and I feel so. I want to apologize to the gentleman from Texas that got very vulgar. That was horrible. That was terrible. And I'm also from Michigan. Have you noticed how angry people are when they talk? I'm not angry over this, and I'm going to tell this gentleman that you're talking about, he hasn't done his job. He better start doing his job if he wants to talk about what about the top to the bottom. I know where the private servers are at, and I know everything else. That's all I got to say. I can't say any more because I probably got my line bugged now. They're probably going to be knocking on my door. I'm just telling you.
That's Phyllis in Arlington, Texas. If this weren't about the Clintons, this wouldn't be a case.
Actually, it's just the reverse. There are federal employees all over this government and former federal employees who have had their clearances revoked, their jobs taken away from them, and who have gone to prison for compromising a single piece of classified information by not storing it properly, by leaving it out on their desk overnight, by giving it to someone who wasn't authorized. This happens regularly. In fact, Mrs. Clinton is being given the benefit of the doubt because she is such a famous and important person, both as a former First Lady, a former United States Senator, and a former Secretary of State. She is being accorded a kind of deference in the investigation by the FBI and the Justice Department, which would not be accorded to a common citizen. So the lady from Texas is absolutely wrong. In fact, Mrs. Clinton, and by the way, I'm not against that as long as the FBI is doing their job. There's no reason to break into people's houses and confront them or go to their homes like the FBI usually does. In a case like this, you know what the FBI does? They find 20 people who are involved in the case. They'd never go to their office. They go at 6 o'clock in the morning, they knock on the door of somebody's home, they say, "Hi, I'm John Smith from the FBI, can we talk to you for a few minutes?" Most people never want to say no to an FBI. They let them in, they tell them everything they know. That has not happened once in this case with Hillary Clinton. And the reason it hasn't happened is she's being given special treatment. But in one sense, that's okay. It isn't in one sense, it isn't in another. We don't need to treat somebody like Mrs. Clinton with disrespect, but we do need to treat her like anybody else would be treated in an investigation. And as far as I can tell, the FBI is doing just that. They're treating her the way they would treat anybody else, except they're not sort of knocking down doors and knocking on people's door on Fifth Avenue in New York at their $2 million condos at 6 o'clock in the morning.
Next call is Bill in Scottsdale, Arizona, Republican line. Hi, Bill.
Hi, thanks for taking my call. So two closely related questions. The first one, do you think that there's merit to the position that Ms. Clinton and others have brought up that there's a problem with overclassification in the current system and complexity of different kinds of classification? And as a related question, in light of, for instance, the recent massive hack of the OPM by probably Chinese government agencies, when you're talking about the threat of penetration by, China or Russia or any actor that has extremely sophisticated capabilities in that regard, how much greater security are you actually getting on government hardware versus the private route that Secretary Clinton took? Because it seems like, at least in part, the outrage is over the exposure of classified information to foreign observance or penetration. So
all right, Bill, I think we got the point. Thank you. Joe DeGenova.
I think I'm trying to remember the first part. The first part is overclassification. There's some overclassification in the government. That's fairly obvious. Anyone who's lived in this town knows that overclassification is a problem. However, in the situation we're talking about here, we're not talking about overclassification. That is a post hoc argument that has been made by the Secretary and her defenders. We're talking about, let me give you an example. In this case, there are 25 emails which have been taken off of the Secretary's server, which are top secret special access programs. Those are accessible by very few people in the United States government, and yet they went through the computer. That is not about overclassification. That's about classification and the nature of the information that's inside that particular. So this case is not about overclassification. Some of Mrs. Clinton's defenders have raised the issue of overclassification as kind of a distraction, and it's an interesting thought, but it has nothing to do with her server. She has raised the issue of post-disclosure classification, which of course is when you put a stamp on something. That information was classified the moment it went wherever it went 4, 5, 6, 7, 8 years ago, and that's the standard that is used. As far as anything else, at this point, believe me, overclassification is not her problem.
Lead editorial, USA Today. Clinton's private email setup undermined Open Records Act. USA Today writes, but the original sin is neither complex nor open to partisan misinterpretation. It involves compliance with the open records law known as the Freedom of Information Act. FOIA.
Well, that is absolutely correct. As I said at the beginning of this, why was the server put in Chappaqua? It was put there, and there is no government email account for Mrs. Clinton. There are no records on that account, and here's how we know that. When people filed Freedom of Information Act requests to the State Department, for a number of years, they got back things saying, we have no records. It's called a no records response. Now, think about this for a second. No records for the Secretary of State on any email account in the State Department. Alarm bells should be going off everywhere inside the State Department, and yet they didn't. And the State Department filed affidavits under oath that there were no records. Yet, at the same time, there were people in the State Department who knew that Mrs. Clinton had no government account, but that all of her emails were going through a private server, unsecured, in Chappaqua, New York. This server was set up to do exactly what it accomplished. It was designed so that no records would exist at the State Department, so that when Freedom of Information Act requests were filed there, the answer would be, we have no records. Judge Sullivan, a couple of blocks from this building, has just issued an order allowing Judicial Watch to do the depositions of a number of people around Hillary Clinton as to how they set this up, why they did it, and more important than anything else, why didn't they tell the court that they knew where these records were while the State Department was saying it didn't know where they were? Because they were notified, all of these people around Hillary, including the Secretary, were told, we have a Freedom of Information Act request under a federal court order. Where are the records? And none of them told them about the server. That's why they're all going to be put under oath in front of Judge Sullivan.
But why would a activist group like Judicial Watch be given permission to depose people?
Well, remember, Judge Sullivan is a Clinton appointee. He is not some wide-ranging, right-wing, radical jurist. He is deeply offended by the fact that the Freedom of Information Act, which is designed to say, if I want to find out what's going on in government as a citizen, if you as a journalist want to find out, if Congress wants to find out, if the press wants to find out, they're entitled to file a request, and the government has a legal duty under federal law to respond honestly and produce the records. And if they don't produce the records, they have a duty to say why. The State Department here said, we don't have any records. Well, of course they didn't, because the server was in Chappaqua, New York, which they say they didn't know about, but somebody did. So the answer is, we have placed since the 1970s and the presidency of Jimmy Carter immense significance on open government and access to public records. This system was designed to deny access to public records for 4 years, records that belong to the people of the United States, not Mrs. Clinton.
Next call for Joe DeGenova comes from Christina in Rochester, Michigan. Independent line. Go ahead, Christina.
Yes, Mr. DeGenova. I have been aware and watched you and your wife for years. I haven't seen you for a while, but I'm not surprised you're out now. You and your wife are very, very, very Republican. I've got a couple things I'd like to ask. Do I have a right to know as a citizen what Cheney and Chalabi were talking about. How come we still haven't found out who Cheney met with way back in 2001 for his energy? We weren't allowed to find that out. So when it comes to Republican things, I want to know, where have you prosecuted or given all your wonderful experience when it comes to anybody Republican?
And that, just to add on to what she had to say, this tweet from Jack Hutton: ask him about his partisan bias, ask him who is funding him.
Well, actually, I'm funding myself. I have a law practice in Washington, D.C. with my wife and my son, and we earn money through legal fees. We receive no outside funding from anybody, any organization, the Republican Party, George Soros. No one gives us any money, especially Uncle George. This is part of the political process in the United States. What's interesting is I've been doing television for years, starting when I was U.S. Attorney, and thereafter for almost 30 years now. I've never had a PR person. I get calls from the media. People want to talk to me. You guys called me. You said, come on in and talk about this. I didn't solicit this interview. So the issue is, by the way, just to know, when I was U.S. Attorney, I prosecuted one of the biggest insider trading cases in history, and it involved the Deputy Secretary of Defense, who was a highly placed Republican. And we went on like that for years. When you're a prosecutor, it doesn't matter who somebody's political party is. But I understand the lady's question. You know, people are entitled to feel what they want to feel. What matters are the facts. What's at issue here is not what I think. It's what the FBI thinks. There's a grand jury for a reason. It's not because the FBI is a tool of the Republican Party. Some of Hillary's supporters have said that Mr. Comey is a tool of the Republican Party, that the Inspector General of the intelligence community is a tool of the Republican Party. The Inspector General of the intelligence community is a former FBI agent during the Clinton administration. So all of these wild allegations, they're wonderful. I love it. It's part of the political process, and I think it's terrific that the lady can call and ask a question like that. Happy to answer it.
And David Brock, founder of Correct the Record, a pro-Clinton super PAC, has an opposing view op-ed this morning in our editorial in the USA Today paper. This is not a scandal, he writes. There was no security breach of Secretary Clinton's email or server. Secretary Clinton has acknowledged that the decision to set up her email this way was not the best choice. She has taken full responsibility for that decision and took the unprecedented step of asking the State Department to make all her work-related emails public.
Well, Mr. Brock is a famous partisan who supports the Clintons, and he is entitled to do so. And I think his op-ed piece is interesting. Although it's wrong in so many places, it's hard to know where to begin. In fact, the creation of the private server, ipso facto, from its inception, as General Hayden called it, the original sin. It was illegal. That was an illegal act, the establishment of that server, to provide all the email for Mrs. Clinton and all of her staff and have all government information go through it. So the rest of it doesn't make any difference, what she's agreed to or what she wants to have released. She doesn't have any control of it. It's not her property. The emails belong to the United States government. Even the ones she deleted, which she says are personal, that's not her property. That belongs to the United States government. The FBI is investigating what was deleted because it is a crime to delete information from a server when it has government information on it. So I welcome Mr. Brock's op-ed piece. I hope he continues to write more.
David, Pasadena, Maryland, Democrats line. Please go ahead with your question or comment.
Yeah, hi, good morning. A couple of callers here preceded my thought about this gentleman being a partisan, a Republican partisan, especially during the Clinton administration with him and his wife. And I want to just give everybody an example of the innuendos that he drops that will clue them into whether to believe what he says or not. He mentioned that he's only being funded by his law firm, and he snidely made a comment, but not George Soros. Well, here's the crux of it. Sorry, you being funded by were you ever funded by Richard Mellon Scaife or the Koch brothers?
The answer is no.
You didn't say
the
that.
answer is no.
Okay, but the fact that you didn't say that, you just left it hanging out there. Now,
keep asking. Do you have a list? Are you like Joe McCarthy? Do you have a list?
Yes, sir. We have a minute to ask questions. You have the whole screen. Okay, so here's my question. That was a comment. My question is, you mentioned other Secretary of States did not have the server in the basement of their house, that ominous basement of their house. How many other Secretary of States that had their servers, elsewhere, had Secret Service surrounding their house and guarding the house because the woman's president a husband was president of the United States.
David, we'll revisit that. What about, again, Joe DeGenova, Secretary Rice, Secretary Powell, who also used personal email?
Well, here's the difference. Each of them admits that from time to time, instead of using their .gov government server, government email account, they sent messages on their private email. And they admit that they shouldn't have done that. However, and Ash Carter, the current Secretary of Defense, indicates that he was using his private email almost entirely for his DoD communications, and he realizes that was a big mistake when all of this exploded. Mrs. Clinton's case is entirely different than Secretary Powell, Albright, and Rice. They did not have a private server anywhere in their life for the conduct of all their government business, whether it's a basement or not. Mrs. Clinton had no other server other than the private server at Chappaqua, New York, at the House. Every bit of government business that she did went through that server. Whether this gentleman likes it or not, that was not the case with Secretaries Powell, Albright, and Rice. And when Mrs. Clinton did that, when she set that up, she committed a crime.
And David Petraeus was using a Gmail account, wasn't he?
He used a Gmail account, and also in Petraeus' case, which is why he pleaded guilty to a misdemeanor, he actually had in his possession highly classified handwritten notes about ongoing operations. And he gave copies of those notes to his mistress and biographer. Clearly an illegal act. Clearly something he should have been prosecuted for, and he was. And in fact, this morning, he was giving an interview, and he indicated in response to a question, do you think Mrs. Clinton is being treated unfairly? And he said, absolutely not. He said, I think she's being treated fairly. I think the investigation has to go forward, and it appears to be a fair and justified one.
Time for a couple more calls. Dan is in Iron Ridge, Wisconsin, Republican line. Go ahead, Dan.
Yes, good morning. The fact that this had to come from the top down. And the fact that she had this server set up by the government and that she erased any material on it is a criminal offense, in my opinion. She should have never erased anything. And since it's a government server, anything she put on it should be the government should be able to take and use it in an investigation. And now, I don't know who helped her set this up from the top down, but it's going to point to people, and I don't know if people are going to bail on her or they're going to back her up. But I think what she did is just totally against the law, and I bet you $10 this all points back to something that she did in Libya. And if that's the truth, then they're going to hang her for it, and I hope they do.
That's Dan. Any comment for him?
Well, I think the issue is, as I said to people, it's the server, stupid. This whole case goes back to where it was put, why it was put there, and who put it there. That's why Brian Pagliano was immunized, because he was present at the creation, as Dean Acheson used to say. He was present at the creation of the crime. He is therefore a central witness. By the way, David Brock, who is an interesting fellow historically, receives a lot of money from the Clinton Foundation and third parties that the Clintons own.
Another tweet for you. Please ask Joe DeGenova to discuss the specifics of retroactive classification.
Well, what happens is something is found, and it doesn't have a classification mark on it. And so usually the agency, if it's something that's serious, they'll look at it. And if it comes from a person senior enough in government, they analyze it and they say, well, this was not classified by being marked at the time. And when it was sent, it was a piece of classified information. So now for future people, we will mark it in a certain way and say it's classified. It just means that something wasn't marked at the time. It doesn't mean that it wasn't classified. Classified information is classified from the moment it's created, whether it is marked or not. When it's marked later, that's to help other people down the road understand something.
All right, last call for our guest is Cornell in Tulsa, Oklahoma, independent.
Oh, hello, Joe. I remember you from the early 90s when you were, I think George H.W. Bush appointed you to investigate something in regard to the tampering of Bill Clinton's passport. You appeared on Fox News constantly doing the Monica Lewinsky
Did he get that
scandal.
correct?
I didn't even hear from you.
No, I wasn't appointed by George. I was appointed by federal courts.
George W. Bush. But let me
Actually, you did. I was a great critic of Alberto Gonzalez.
On January the 7th, will you apologize once Hillary Clinton is not indicted for anything? And she won't be indicted for anything, Joe. Will you finally be man enough to apologize? And thank you.
That's Cornell and Tulsa.
Yes, well, actually, what we're doing is we're doing legal commentary on something that the FBI is investigating. It is now beyond any doubt that there is a criminal investigation of the conduct of Mrs. Clinton in placing a private server in her home. There's nothing to apologize about. By the way, I take no pleasure in Mrs. Clinton having this problem. I do take a great interest as someone who has prosecuted espionage cases, who currently holds a top secret and above security clearance, that these things mean something. And for people who don't think they do and violate the law, they should be held accountable.
Okay, another tweet. We're going to keep you a few minutes later than we were supposed to. I apologize.
Don't apologize.
Was General Petraeus covered under the whistleblower laws?
Not to my knowledge. Nothing that he did or said would have had any basis whatsoever in being a whistleblower. He actually was someone who had classified information, knew it was classified, and had a duty to protect it, and he didn't protect it, and so therefore his prosecution, I think, was justified.
Another tweet for you. Sounds like of all the secretaries, HRC's server was more secure than Gmail, Yahoo servers.
Well, I don't know how that person would know that, since the FBI is investigating whether or not it was compromised, and since it was not encrypted, according to information from Brian Pagliano, which has now been leaked to the public, the server did not have any special encryption. It certainly didn't have government encryption because it couldn't, because it wasn't a government server. So there's no, by the way, I think OPM and the compromise, I'm one of the people whose information was compromised at OPM because of my security clearance. They got my information. They got my wife's information. So believe me, we believe in strong servers with great security systems, and Mrs. Clinton's server didn't have any of that, regrettably.
All right. As a lawyer, former federal prosecutor, we're going to change gears just a little bit here. We're going to show you a quote. Want to see if you can identify who this is from and what you think of it. Judge Garland is a profoundly serious guy who really would be the kind of person you want to have on the Supreme Court. If Obama wants to get a fantastic judge on the court, he's got one ready to go in Merrick Garland. This is from the New York Times, April 27th, 2010.
That's me. I said that about Merrick Garland. I've known Merrick for many years. He is a fabulous judge. He's a decent human being. He's a wonderful guy. And unfortunately, he's gotten himself in the middle of a political battle where his merits are not the issue. It's whether or not the Senate is going to stand up for its rights. And, you know, that's just the way it is. But he's a great guy. I love him. I think he's a phenomenal person.
And in fact, in this morning's USA Today, Alberto Gonzales, the former Attorney General for George W. Bush, said, give Judge Garland a Senate vote.
And they may very well do that, but I understand the Senate's position as well, that they're not going to do it until the... By the way, he may end up getting on the court. If Hillary wins, the Senate might confirm him right away in an effort to block a more liberal candidate. If that happens, so be it. The process is going to be delightful to watch.
Joe DeGenova has been our guest. We appreciate the legal lesson as well. And by the way, his wife, Victoria Tunsing, and his law partner will be on Book TV this weekend. She'll be interviewing John Yoo about his most recent book. So that's on Book TV this weekend. Joe DeGenova, thanks for being with us.
Thank you very much. It was a real pleasure.
And we've got a little over...